I'm going to analyze the first courtroom scene in the TV show The Wire.
What?
Your case just hit the wall. Barksdale's crew, they turned it.
2 eyewitnesses and a statement. No fucking way, pal.
State Attorney's Office.
I have seen this scene play out in real life, and I think it's a great tool to highlight the defense strategies and issues that come up in a homicide case. Because it's an excellent case study of how big city homicide prosecutions usually play out. The facts in this case are that the defendant is accused of getting into a fight with someone in one of the project towers, and in retaliation, shooting him in front of 2 eyewitnesses. Those 2 eyewitnesses are the key to this case, and they're both testifying in this trial. Let's look at the first witness.
Mr. Gant, do you see the man you identified from that photo array card sitting in the courtroom today?
He's right there.
So the eyewitness has got to the point where he's asked to make an identification, and just before he does, you see one of the associates of the defendant walk in. This is a problem in courtrooms where the associates of the defendant come in and sit there and glare at witnesses in order to try and intimidate them from actually testifying or making an identification. So that's what that scene is highlighting.
He's right there.
Thank you. Just one question, Mr. Gant. Had you ever seen this young man before the day in question?
No.
No further questions, Your Honor.
So you see the shock on the prosecutor's face when the defense attorney asks one question. Now you have to understand that this is an eyewitness, a key witness to a murder, who's identifying the defendant. To only ask one question on cross-examination is a bold move. However, it can also be an effective move. What the defense attorney is doing here is he's teeing up argument for the closing. And that argument is going to be that it's a misidentification, that he just got it wrong. And he doesn't need to go in there. He's never going to get that witness to say, no, I was wrong, I'm sorry. He identified him in the photo array, and then he also just did it in court. But he's teeing up the argument by asking him, have you ever seen this person before? So he may have made a mistake. And when the standard is beyond a reasonable doubt, that can be a compelling argument. But the real strategy behind this one question cross really comes down to the second eyewitness who's going to come. Now, 2 eyewitnesses is powerful corroboration. If you have 2 eyewitnesses identifying someone, the likelihood of a jury convicting is high. If you just have one, and it's a person who's never seen the defendant before, then there could be a mistake, and that could be a reasonable doubt.
And what is your occupation, Miss Lyles?
I'm a security guard.
And were you employed as a security guard on May 4th, the day of the shooting?
Uh-huh. I was in the booth of 221.
And is that the guard booth in the lobby of the Fremont Avenue high-rise?
Yes.
She opens the questioning by asking her where she was in relation to the shooting, which is the guard booth. That would give her a good opportunity to observe the perpetrator, the defendant in this case. When you're analyzing the strength of an eyewitness's testimony, their vantage point and opportunity to observe is a key determination, and that's what they're establishing through that line of questioning.
And do you see that man in the courtroom today?
Nope.
I have seen that before many times. When you see someone staring around the courtroom looking everywhere, they're usually about to screw the prosecutor over. They know where the defendant is sitting. Everybody knows that. But she's trying to put on a show to the jury that she's giving a good hard look around the courtroom just like she was asked.
Excuse me?
He ain't here.
You testified. Ms. Lyles, do you remember when Detective Barlow showed you this photo array?
Yeah.
Good. I call your attention to your initials, which identify this photo as the man who shot Mr. Blanchard. Did you write your initials above that photograph?
He ain't the one that did the shooting.
But you identified him.
Well, that's because he looked like the boy that did it. See, the one that did it, I saw him come in the building a week later.
You saw someone else you thought did the shooting.
Right. A week later.
So now the eyewitness has gone south. In other words, she's testifying inconsistently from her initial statement where she was showed a photo array and she identified the defendant. So the first thing a prosecutor is going to do in that instance is bring that photo array out to say, well, at a previous occasion, you actually ID'd this photo. You know that the defendant's associates have got to this witness because not only does she say, I don't see him, I don't identify him, but she actually has a follow-up story which she's using to bolster her credibility and sprinkle doubt into the case. And she does this by saying, no, actually, I saw the guy a week later.
Miss Lyles, when you spoke with the detectives, you never said anything about
I tried. I called Detective Barlow on May 13th at 2 p.m. But he didn't call me back.
Nicely done.
You called Detective Barlow?
Yeah, twice. Yeah, I wrote down in the log.
And then when they try to impeach her on that by saying, well, why didn't you go to anyone to say that? She also has an answer for that, which is, I tried to call Detective Barlow, but he didn't answer me. Now that looks like the police made a mistake, which the defense would certainly hammer in closing. Now, when you look at this second witness's testimony, which the defense attorney obviously knew was coming, it now makes a lot more sense in terms of how he dealt with the first witness's testimony by only asking one question. You see, he didn't want to beat up that first witness. And in closing argument, he's not going to beat up that first witness. He's going to say the guy came in, he tried his best, he thought he saw something, but he was wrong. And that's exactly what the second lady did. She thought that she saw the right guy, which is why she circled the photo array at the time. But then later, she realized that she thought she saw the other person. Now, ladies and gentlemen of the jury, eyewitnesses make mistakes all the time. They're far away, they don't have an opportunity to observe, they've had a traumatic event, and they can make a mistake. So the question is, are you going to hinge your verdict of guilty beyond a reasonable doubt on this type of evidence, where we have an inbuilt uncertainty by one of the eyewitnesses who came across very credible? She sounded great, it didn't look like she was trying to hide or obfuscate anything, she answered all the prosecutor's questions, but she swore an oath to tell the truth. And that was to let you know if she saw that person, and she honestly did not know. And that is how in this scene, even though you have two eyewitnesses who were close and saw everything, they beat the case because the second eyewitness was obviously intimidated. Now, obviously intimidated doesn't necessarily mean coerced, by the way. You can also intimidate a witness by offering them something, regardless of how you do it, whether it be by carrot or stick or just persuasion. And this is how a lot of homicide cases play out. And the hardest part about these types of homicide cases is that when they have something like two eyewitnesses, so detectives arrive on the scene, they see two eyewitnesses, they clearly identify the person, they don't usually follow up as much because they think they have the case in the bag. What's more is that these two witnesses, one of them was a security guard and the other one didn't appear to be some sort of gang member. What that suggests is that they look like credible witnesses who will come to court and will testify truthfully. You usually will have a bigger issue if you're trying to deal with, say, the ops, right? The opposing gang members or the opposing drug block. They're the ones that are less likely to actually cooperate. But when you're dealing with regular citizens who come in, you expect them to testify truthfully. You don't really follow up any much more than that. But it also means that when they go south, they come across credible as well. So although they're departing from their initial statement, their entire demeanor suggests that they're telling the truth and that they made an honest mistake. So that's how the fix was put in on this case, and that is how the attorney got a not guilty on this case. Now, an attorney obviously cannot participate in a scheme to intimidate any witnesses. That is obstruction of justice. You're not just going to lose your license, you're going to go to jail for that. You cannot play that game. However, there are other more subtle ways to communicate that. When you're meeting with the clients, for example, and they're having a conversation and you're saying, well, you got two eyewitnesses here, so what do you want me to do with this case? You have two credible eyewitnesses. One of the associates in the conversation says, well, what if there were no eyewitnesses? Or what if she changed her story? Or what if she doesn't say that she ID'd him? Well, in that case, we would actually have a pretty good shot, because that would be a reasonable doubt. But unless that happens, and I'm not advising you do that, then the likelihood of winning is almost nil. Months go by, case comes to trial, ta-da, the witness has testified inconsistently, gone south, and the case has also gone south.